Much, Krista.
You're welcome.
Thank you so much. Krista is our behind the scenes, in the studio operative, and as usual, doing a fantastic job. Good morning, everybody. It's great to have all of you in attendance. We have with us today James Greenspan, who manages our commercial insurance group, and we have Raj Bhardwaj, the attorney who manages our workers' comp group. So just hope everybody's doing fine. Hope everybody's doing well. It's gorgeous weather. It was a great weekend. There are hints that things are going to be opening up again soon. So perhaps we're at the beginning of the end of this. Let's keep our fingers crossed and keep praying that we are getting ready to see get back to some level of normality. So having said that, again, welcome all of you. Today's topic is something that is kind of interesting because it occurred to us probably last week that in the treatment of COVID-19 patients, many providers may find themselves in an environment that they are not accustomed to. So, for example, you have pulmonary doctors, cardiologists, who typically are not seeing, for example, workers' comp patients. They're normally in their practice, unless somebody has a heart attack caused by their work or happens in the workplace, they're not likely to be, a cardiologist not likely to be seeing a workers' comp patient. Same thing with a pulmonary doctor, unless there's some lung-related disease that's contracted at the workplace. But these are typically not situations that pulmonologists and cardiac doctors, cardiologists find themselves in. So we thought, oh my gosh, if those types of specialties are treating COVID-19 patients, it's very likely they're not familiar with the ins and outs of reimbursement. And that treatment, even though the federal government is speaking a great deal about treatment and reimbursement for that in one way or another, typically it's to ensure that the patient doesn't get a balanced bill, but it all falls within perhaps the state regulatory frameworks. Similarly, doctors that may not be on ER call may suddenly find themselves doing nothing but treating ER patients. So even if you're a pulmonary doctor that typically does not work out of the ER, and all of a sudden you're seeing ER patients, there is a whole regulatory scheme that comes into play with commercial insurance carriers that is implicated. So having introduced all that, that is the reason James is here, is because the state surprise medical bill arbitration process is relevant to out-of-network ER treatment. So some of these doctors that may not be familiar with ER regulations when it comes to reimbursement should probably be educated about it, and that's the beginning of this. Raj is here as well because of the workers' comp implications that I just mentioned. So without belaboring the introduction too long, I do want James to address first the CI commercial insurance surprise medical bill arbitration process. And then Raj, I will introduce to discuss some of the workers' comp regulations. These are just the typical regulations and reimbursement schemes that exist out there in these in each of those respective environments. So it is something they are thoroughly familiar with. And so any of you out there who are either treating in environments that you previously weren't very active in, please take heed. And if you have colleagues who may be in specialties that typically aren't in these environments, it would be good to get them on board in some way, shape, or form. We do have a blog coming out on this very subject. We do want to make this video available as well. So we will be sending out to people that are interested an email blast with both the video and the blog link. So that will be forthcoming. So having said that, James, I'd like you to address the audience first. And please do so as if you are addressing specialties that have no experience with the surprise medical bill arbitration process, so that they at least get a broad brush. Yep. Hey, Sean.
Hey, Sean. Yeah, can I just jump in real quick for 1 minute?
Sure. Yep.
Yeah. Yep. Hey, so first I want to thank everybody for being here. It's Sean Callagy of Callagy Law. Thank everybody for being here again. And, you know, the idea of using this time to adapt, to accelerate, overcome the stabilization, survival, and even growth of practices is what this is about. Tom, I want to acknowledge you, James, and Raj for doing fantastic work in this area and providing all this. And for anybody listening out there, you know, a lot of our focus at Callagy Law is holistically helping. It is certainly helping you build, collect, innovate your processes, but that also includes how you build relationships and grow. You've heard me say this each week. We are having the opportunity with something we're doing for speaking engagement opportunities that I think will be directly beneficial and indirectly beneficial in terms of advancing your skill sets as a speaker, relationship development. I will say this is the final, that during this time period, I think the medical world and how commercial insurance, HIP, and workers' comp function, the patient base, the marketplace of employers, attorneys, relationships is going to be disrupted substantially. And it is a great time to build your new relationships rooted in integrity and accelerating forward. So if anybody's interested, Crystal will put the link in for the Railroad Role Play if you're interested in either being a judge or a participant, meeting incredible national level speakers. We've had some of the top people in functional medicine in the country, top national lawyers, speakers, et cetera, on, and you're more than welcome to participate in this. And there'll be other upcoming information about all the resources we're providing for you to continue to grow your practice. But speaking equals growth, microphone and stage equals growth of relationship and practice. Please take us up on it. Tom and James and Raj, back to you.
Thank you, Sean. Thank you, Sean. Okay, so James, why don't you take it away at this point and discuss the surprise medical bill arbitration process?
Sure, will do. Thank you. Good morning, everybody. Again, thank you for being here. We really appreciate it. We hope you will find at the end of this that it has been time well spent. And of course, we are so thankful for all the medical providers and their office staff supporting them who are out there on the front lines day in and day out, putting not only themselves at risk, but also, you know, their families who didn't even sign up for that kind of thing. So thank you from the bottom of our hearts. We really appreciate everything that you guys are doing. And in our own little way, we hope that this type of a presentation can help you guys and your offices, you know, recover during this crisis. So I'm going to talk first a little bit about the out-of-network surprise billing arbitration process, and then we're going to throw it to Raj. And then I think we're going to maybe talk about what kind of overlap we foresee potentially coming based on, you know, some of the stuff Raj is going to talk about and how maybe we're not going to go first, whether it's workers' comp or not. So we'll get to that towards the end. But as a starting place, just to sort of introduce those of you that aren't familiar with it, in 2018, New Jersey created a surprise billing arbitration law. There had been a lot of lobbying from patient groups that, you know, if someone went to the emergency room or was even treating with an in-network doctor and had an elective procedure, they were getting these balance bills from out-of-network providers like anesthesia groups, intraoperative monitoring, or even just in an ER context, an out-of-network doctor, or, you know, if a woman was giving birth and treating with her primary care doctor at an in-network facility, you'd still get balance bill from, you know, the anesthesiologist or sometimes the hearing tech, all these other doctors, these inadvertent or emergent surprise bills. So in 2018, the legislature created a new law to deal with all of that. Governor Murphy signed it into law that summer, and it went into effect on August 30th of 2018. It essentially just says the patients are going to be completely kept out of this. The patients, if they treat emergently or inadvertently out of network, are only going to be responsible for their in-network cost sharing, which is copay, coinsurance, and deductible. So, you know, essentially the Congress was saying, look, it's not their fault. They got treated emergently or inadvertently. They didn't even know about it. So we're going to hold the patient harmless, essentially, and the patient's only going to be responsible as if it had been in network. So where does that leave the medical provider who, you know, is out of network, doesn't have a contract with the carrier? How do they recoup their money? To fix that, Congress created this arbitration system, and it's good. It's not perfect, but you know, I think it's a step in the right direction that I do hope we'll see improvements over the coming years. But for now, essentially what we're looking at is a dispute and negotiation process between the medical provider and the insurance company. So the way that it works is that when the carrier gets it is supposed to identify it based on the circumstances, maybe the op report, maybe, you know, if there's an emergency indicator on the HCFA, that it's emergent or inadvertent services for the patient. And the carrier, when paying the claim, is supposed to place on the EOB some kind of notice, one of those explanation codes that's going to say, hey, you know, you're not a network provider. We've identified these possibly as emergent or inadvertent services, and therefore it's subject to this law. You cannot balance bill the patient. If you don't like what we paid you, then you have to dispute it and attempt to negotiate it with us. And you have 30 days under the law to do so. That's the way it's supposed to work. In reality, we're seeing that there are some glitches. Not all the carriers are fantastic about putting that notice on there. Some of them won't put it on there. Some of them put it on every single time, so you don't really know whether it's subject to the act or not. Those are some of the wrinkles that we're still trying to iron out individually with the carriers or in association with New Jersey's Department of Banking and Insurance, with whom I'm unfortunately in contact with on a weekly basis, if more often than that. But essentially, assuming that it's the way it's supposed to work, the carrier puts on the EOB, hey, this is an emergent or inadvertent service. The provider then has 30 days to write back to the carrier, we dispute that. We think that what you paid us is too little, we want more, and then the parties enter into negotiations. I have seen some cases settle. Some of the carriers are better than others in terms of actually providing reasonable settlement offers. Far more often, unfortunately, the parties are not able to reach a settlement, and then you're going to enter into the arbitration process. So I don't want to get too down in the details, but essentially once the negotiation period ends, if the parties have not settled the case, the carrier has to submit what's called its final offer. It has to pay the provider, you know, some amount that it says, look, this is my final offer, sort of like, what was that show back in the day? Is that your final offer? Tom, Raj, help me here. Who Wants to Be a Millionaire? Yes, thank you. Sort of like Who Wants to Be a Millionaire, you know, that's the carrier has to take a position and say, this is our final offer we think is reasonable. And then if the provider does not like that final offer, they get to file for arbitration and they get to submit their final offer. And the arbitrator at that point gets to sort of look at everything and is tasked with picking one or the other in what is known as baseball style arbitration. There's no proverbial splitting of the baby. There's no compromise in the middle. If the arbitrator thinks that $5,000 would have been a reasonable number, but has to pick between $200,000 and $10,000, you know, then the arbitrator maybe has to say, in that case, the 200 would be closer. So, you know, it kind of gives both sides incentive to be a little more reasonable, the carriers to pay a little bit more, the providers to ask for a little bit less, which has the added benefits of fostering some more settlements, and you know, both sides are a little bit more reasonable probably when headed into the arbitration. And the whole thing kind of wraps up in about 60 days, so it's pretty quick and painless if it's operating the way it's supposed to. So yeah, Tom. Sorry.
So James, so let's play this out in a hypothetical scenario, which is probably the most common scenario that's going on out there, I would guess. So a COVID-19 patient comes into the ER, right? And maybe the hospital is not in network with the patient's carrier. So the patient comes in, gets admitted, and let's just assume for a minute it's an out-of-network hospital. So maybe the hospital's in network with all the major carriers, but they just happen to not be in network with Meritain or some carrier that's not one of the big four. one of the four horsemen of the apocalypse. And the hospital's not in network with them. So the patient comes in, gives the health insurance information. So it all of a sudden ends up being an out-of-network ER treatment, correct? So, and let's say it could also be an out-of-network pulmonary doctor that over the course of 2 weeks, perhaps 3 weeks, that patient is admitted and is in the hospital. So that out-of-network hospital bill is going to be fairly significant because it's an extended stay. The pulmonary doctor may see the patient, I don't know, 5, 6, 7, 8 times over the course of those 12 days, depending upon how often he's going to be on duty. But he may have, I don't think it's too far-fetched, the hospital may have a bill, an inadvertent or out-of-network emergency bill, right? And let's say it's a state-regulated plan, which is a requirement. It's not an ERISA plan. So it's a state-funded plan, a state-regulated plan. And, the hospital has a bill of $30,000, and the pulmonary doctor has several evals or whatever else he might be doing for that patient, and his bills amount to $6,000, $7,000. Play out typically how that is going to get paid, and then what the results of the out-of-network arbitration might look like in a hypothetical scenario.
Sure. First, Chris Dalton, shout out to you, said, complimented you, Tom, on your four horsemen of the apocalypse comment. So shout out to you. And to
Thank you, Chris. Thank you, Chris.
Sure. So let me take the hospital first. And let me say, I think you're probably being conservative on the low end of what a bill like that would look like. If you're talking about a patient that's emergently admitted for several weeks and is even maybe on a ventilator, I think you're probably looking at something in the 6 figures in terms of how much it's going to be. So normally what we're seeing is that the carriers have taken a position that something that's reasonable, air quotes, is based on a percentage of Medicare. I'm seeing anywhere from 125% to 200%, sometimes even 250% in terms of the final offers, but you're mostly going to be dealing with a percentage of Medicare. So again, the way it's supposed to work is, the hospital puts the bill together. It's going to include all the services, and let's say it's, that $100,000, and sends it to the carrier. The carrier processes it and sends it back, and says, we think $7,500 is reasonable payment for these services. And oh, by the way, here's the explanation code. It's subject to the Surprise Billing Act. So at that point, the hospital has 30 days, and it is a very, very strict time window. The administrator of the program, Maximus, literally to the day will count and take a look at everything. So if it's 31 days or 32 days, the facility is probably going to be precluded from arbitrating. So it's very tight timelines. It's important to be on top of this stuff. But assuming that they timely dispute it, we call it internally a red flag letter, a dispute letter, back to the carrier to say, look, we're not in network with you. We do not think that the $7,500 is an appropriate payment for these services, and we want to negotiate more. The parties have 30 days to negotiate. We're seeing a lot of things like zealous or multi-plan offers that are incrementally above what they have originally paid. So on the $7,500, you might be getting a multi-plan offer for $8,200 or $8,600, like real low increments here. They're only increasing it by percentage points. I'm really occasionally, surprisingly, but rarely seeing substantial settlement offers, $30,000, $40,000 on a bill like that. But most of the time, the parties don't reach that settlement and they would enter into arbitrations. So after the 30 days expires, the carrier has 7 days to pay its final offer. And then let's say they paid $9,000 was their final offer. The hospital would have 30 days from that final EOB to file for arbitration. And then the arbitrator would decide between whatever number the hospital submits and whatever number the carrier paid. So let's say they paid the $9,000, the hospital maybe takes a little bit off, maybe the hospital asks for $80,000. So the arbitrator is going to look at everything the carrier submits, some argument based on Medicare, everything the hospital submits, maybe exemplar proofs, maybe fair health, other exemplars, maybe the way that this particular carrier paid it in the past. Maybe they're going to submit some kind of what in-network would have paid. In-network would have paid $20,000, that kind of thing. And then ultimately the arbitrator just picks one number or the other, and then you either win it all or you lose it all from the provider's point of view.
So would it be fair to say, and then we can wrap this up and go over to Raj, would it be fair to say that the hospital in that scenario, right, billed $100,000, was paid initially $7,500, may get paid a small increment more before the arbitration, but goes to the arbitration, and it's these 30-day windows, like you said, let's say prevails in the arbitration and recovers another $60,000. So the hospital that was conscious of the 30-day windows and was conscious of this environment, the difference is approximately $8,000 in recovery versus something closer to $65,000 or $70,000 in recovery for the same treatment. Okay, and applying those percentages, would it be fair to say that a pulmonary doctor who has let's say it's not a $100,000 bill, it's a $10,000 bill. So the pulmonary doctor bills $10,000, gets paid $800 perhaps, a small increment above the $800 before the arbitration, and then in the arbitration may recover $5,500 or $6,000. So that pulmonary doctor that's not used to the ER process, the ER arbitration process, the difference is 7 or 8 or perhaps even tenfold in the difference in the reimbursement. So I think those are realistic scenarios. So one pulmonary doctor who is familiar with the ER arbitration process may get reimbursed $6,000 or $6,500 on his $10,000 bill, and the poor pulmonologist, pulmonary doctor that isn't familiar with it may walk away with an $800 payment and think, hey, it is what it is.
It's not only fair to say, I can guarantee that happens all the time. Any medical provider who works out of the ER that's not actively engaged in this is for sure losing money. We have one plastic surgeon who's a very good client of ours. Last week, we recovered 2 awards for him, one for an additional $30,000 and one for $10,000. So we're talking real money here. I should say the minimum arbitration amount is $1,000. That has to be the dispute. But often when you're dealing with large bills, that $1,000 is almost nothing. Like if you were to bid $1,000, you would almost guarantee yourself a win. So it really just becomes, what level of conservative do you want to be with your bid? You want to ask for an additional 2 or 5 or 10, depending on how big the bill is. But this is definitely a space where providers need to be active. And I should say that Callagy law fronts all of the costs, and if we lose, it doesn't cost the provider anything. So there's literally no risk to the provider. And if they were to wait beyond the 30 days, they would be able to arbitrate anyway. So it's definitely in their best interest to be on top of this stuff as much as possible.
Okay, so now let's change the hypothetical slightly. So rather than coming in to the ER, and my guess is many of the early patients will be in this scenario I'm about to describe, where they come into the ER and they don't give their health insurance. They say, look, I'm sure I caught this at work. There were people that contracted it, and we were still in the workplace really through the first 2 weeks of March, and I'm sure I contracted it in the workplace. So it's treated either sooner or later as a workers' comp injury. So now you have an in-network, out-of-network kind of doesn't really come into play unless, if the pulmonary doctor, I don't know why he would be in network with workers' comp carriers, because he probably doesn't see any workers' comp patients typically. So Raj, in this scenario, you have a specialty that typically doesn't treat workers' comp patients. All of a sudden, they're in the ER dealing with workers' comp patients all over the place, and they probably are completely unfamiliar with the reimbursement requirements under the workers' comp laws, and that would be to their terrible financial detriment, and explain why.
Yeah, certainly, Tom. We do expect to see a rise of workers' compensation claims that have to do with patients being infected with the COVID virus. In the event that they receive treatment relating to COVID and its workers' compensation, doctors should be expecting payments based on UCR. So under the workers' compensation statute, the standard of reimbursement is usual, customary, and reasonable, which is defined as doctors in the same community. So if they're not in network, they should be expecting payment based on usual and customary rates.
Okay, so here I am. I'm a cardiologist, right? And I might be in network with some of the major commercial carriers, but I'm not in network with any workers' comp carriers because I don't see any workers' comp patients. Boom, here I am, and I'm seeing all sorts of patients coming in, and now 90 to 100% of my practice is in the ER, and I'm helping out with seeing COVID-19 patients, and I don't have a clue how this works. My office personnel are gonna be billing a workers' comp carrier. Maybe it's gonna be Liberty Mutual as opposed to Aetna. Maybe it's gonna be the Hartford as opposed to Blue Cross Blue Shield. I'm expecting probably, in my mind, something analogous to in-network commercial reimbursements, which may be 20% of what I typically bill. Now you're telling me, hey, I'm entitled to UCR. So if I see these patients on several times over the course of several weeks, I may have a $10,000 bill going to these carriers, cumulative bill for all of those visits, maybe something else. And now, what are you telling me? Instead of expecting a reimbursement for those $10,000 worth of bills, I'm expecting something in the neighborhood of probably $1,500. And you're telling me you're telling me exactly what? What should I anticipate for that $10,000?
I'm telling you that you should be submitting 100% of your bill, and I'm telling you that you should let Callagy Law kind of argue it out with their adversary respondents. If there is no network fee schedule, then you should be expecting reimbursement based on usual and customary. So you would be submitting 100% of your bill, and then after negotiations, we'll see where it lands, but it certainly will not be landing at 20% of the bill.
So in workers' comp world, for all of those specialties who typically don't operate within that space, the law requires reimbursement at usual and customary rates, at usual and customary levels. Correct?
The law requires reimbursement based on usual and customary levels, which is defined as what other doctors in the same community bill as, and usually that means the GeoZip. And look, there are two parts to this, right? One is you should be expecting the reimbursement at 80 to 100%, whatever it is that we're able to negotiate. But the second part is the workers' compensation claims. Why are these claims being filed as workers' compensation, or why is it that workers' compensation insurance covers these types of contraction of the COVID virus? And I can go a little bit into that, Tom, if you like. And that's basically because we're headed towards a rebuttable presumption for healthcare workers. So what that essentially means that if a healthcare worker contracts the virus during their time in the hospital, there is a rebuttable presumption that they got it while they were working. So then it's up to the carrier to prove through clear and convincing evidence that they didn't contract it through work. Now, in New Jersey, we haven't adopted the rebuttable presumption just yet. There is a bill before there's a bill pending. It's called Bill 2380, and that expands the definition of essential workers to include almost all healthcare workers, in addition to public safety workers like police, EMTs, nurses, etc. And unfortunately, many of these heroes have contracted coronavirus during the course of their employment while helping others. So we do expect them to be reimbursed based on the workers' compensation laws, which provide for UCR at the same level that other doctors would bill in that community, which means that you should be able to submit your bid at 100%, and then sort of leave it up to the lawyers to negotiate it out.
That rebuttable presumption is an interesting concept. I mean, as lawyers, we know exactly what that means. So would you anticipate a lot of carriers probably challenging whether some people contracted this in the workplace or not, and at least in some context with probably the police and the EMS workers and the healthcare workers, that presumption probably would exist and take hold, but perhaps with some other patients that don't fit into those categories, it might be a little more difficult to prove that it happened in the workplace?
Yeah, so the baseline in workers' compensation is that the injury, in this case, it's a virus, arose out of the employment and occurred during the course of employment. So that's sort of the baseline for any workers' compensation claim. When it comes to healthcare workers, we are seeing sort of a shift in terms of the burden. So even if the bill doesn't pass and there isn't a rebuttable presumption, there's still other case law in the state that does support the patient in these type of situations. So I'll give you an example of one case. It's called Birds v. Somerset Hills, and it has to do with a groundskeeper. The groundskeeper was infected with Lyme disease because of infected larvae in the woods. So while he was trimming the woods, he got infected with Lyme disease. Now, he spent 40 hours a week as a groundskeeper, but he also spent several hours gardening in his own home. And the respondents argued, well, you can't prove that he got Lyme disease because of his work in the woods as a groundskeeper. Who knows? Maybe he got it while he was working in his own backyard. In that instance, the court used the standard, and the appellate division affirmed the standard of it was more probable than not that the worker was infected during the 40 hours that he worked as a groundskeeper rather than the few hours that he spent at home in his own backyard. So we're all seeing that this is more of a patient-friendly issue. It's more of an injured worker-friendly issue when, especially during this time, during the coronavirus pandemic. And if the person is a healthcare worker, if they're a public safety worker, for public safety workers, there is already a rebuttable presumption in the statute, but the public safety worker definition is pretty narrow. Now, what we're seeing in the House is that they're trying to pass a bill where that definition expands and includes all sorts of healthcare workers. So whether or not this bill passes, there's already case law favoring the healthcare workers in these circumstances, and ultimately we should be seeing a rise of workers' compensation claims where patients have been infected with the coronavirus, especially healthcare workers.
Yeah, it's interesting too because you hear about, I know some of the food processing facilities out west, where, according to the news, they have very high percentages of employees who are contracting it. And I guess if you come from a work environment where a good portion of the people did contract it, you probably have a pretty good case for that rebuttable presumption, I would think, or at least some form of it.
I tend to agree, Tom. You certainly have a really good case in that instance. And we're seeing that with certainly people in the food industry, in the healthcare industry, perhaps even in public services. So there are various occupations where it's more likely than not that if you did get infected by the virus, it was due to the workplace. And so doctors should be expecting a rise in these claims. And when it does come to that, doctors should be looking for 100% of their bill.
Good. Okay, well, go ahead, Jane. Yeah, go ahead.
This kind of brings me to the point I was going to make before about the overlap between commercial insurance and workers' comp. I think, you know, when you're talking about that groundskeeper or certainly a healthcare worker, it's as to how and where the person contracted it. What about someone who's a clerk at CVS or at Dunkin' Donuts, or someone who is a grocery store clerk or a liquor store owner? You know, these are all people whose jobs deemed as you know, necessary and are staying open, but it's going to be much more difficult to trace on the medical provider end that this person might have contracted at work. And I think, you know, so it's incumbent on the medical providers in their intakes to maybe do a little more digging on the front end about what kind of job this person's working in. Because again, if it is a place where they're likely to have contracted it, or even, you know, if you're a mail carrier, that kind of thing, someone who stayed open, they could have contracted it at work, it's going to be important to try to nail that down early on. Well, why is that? Because this is where the commercial insurance and the workers' comp overlap. If someone comes in, normally they just give their commercial insurance, they're admitted, they have that, you know, 3-week stay on a ventilator. They're going to bill Horizon or Aetna. But then later on, if it turns out it actually was a workers' comp injury, maybe the CI is going to deny it and you're going to have to go to workers' comp, or there's going to be a recoup. So it's really important to identify as early as you can in the process where we think the individual contracted it, if possible. Obviously, you know, people are going to say, I have no idea, but that's where the digging would help. You know, on the flip side, if you're sort of doing it as a workers' comp injury or illness, and then it subsequently turns out that maybe it isn't, at that point, maybe you're a year or two down the line, it might be too late for commercial insurance. So I think provider kind of stuck here in the middle. So my advice would be to, you know, do as much digging early on as you can, take back it about maybe where the patient thinks they might have gotten it, or you know, what their profession is and whether they've been staying open, an emergency worker.
All right. And the interesting thing, go ahead, Raj, go ahead.
That's an excellent point, James. And I do want to stress that taking good notes, especially after their employment, is very, very important for the medical provider, whether it's in the intake, whether it's in the med notes, especially during this time. Having good records is really key in litigating these disputes.
Yeah, and the interesting thing about, you know, both of these forums that we're describing, there's no balance billing of the patient. So there's no balance billing in the state ER arbitration process, and there's no balance billing in workers' comp. So the federal government's policy concerns in all of this seem to have been to make sure the patient's protected from a balance bill. So none of those federal policy concerns really would impact the two forums we're talking about. So I think we pretty much are going to be addressing some of these things strictly from the state legal and regulatory perspectives without any interference on the federal side, but that remains to be seen. But that's at least my guess, because none of this implicates, you know, the patient's finances in any way. So,
Tom, you know, to that point, of course, I support that, and the policy is wonderful. The unintended consequence, however, of shifting any balance billing burden off of the patient is that the now falls squarely on the medical provider. The provider is the one who's stuck trying to figure out, is this a workers' comp injury? Is this a commercial insurance claim? Did I adhere to the timelines? Did I not? Whereas in the past, when you were able to balance bill the patient, often, practically speaking, most providers weren't, but often when they would, it was essentially just kind of leverage, get the patient on board in terms of the appeals process to go back to the carrier to say, look, this was an emergency circumstance. please, reconsider your bill. The patient would write an appeal. The patient and the provider would actually be aligned against the insurance company to try to get the carrier to pay a more reasonable rate. Now, essentially, the provider is left on their own to navigate, just in commercial insurance, 5 different paths in the state of New Jersey you could go in addition to the workers' comp path. So, the providers have more of a burden on their office than ever at this point. So it's really important they know where they are and they're able to bill and follow up on it to try to get paid, because they don't really have the patient as anymore. There's no leverage in terms of balance bill.
That's exactly right. And that's a really good point, and a perfect segue to the conclusion here, which is that underscores how important it is for these medical providers who may not be accustomed to the ins and outs of workers' comp, may not be accustomed to the ins and outs of out-of-network ER reimbursement. So it just highlights how they need to be educated, and how important I think this video is, as well as the blog that's going to be coming out, and how important it is to just be on top of this, because it's a new environment for them, not just because it's not only a new environment because of the virus. It's a new one. They find themselves in uncharted regulatory and legal territory that their office personnel simply may not be accustomed to. So it's new on several fronts, I guess. It's novel for them on several fronts. So having said that, do you guys have anything you want to add to wrap things up? Any final thoughts? Any final remarks?
I just thought it would be worth mentioning, one of the key difference between the two is that workers' comp, you have the 6-year statute of limitations. So even after 2 years, you can bring these claims. And look, perhaps it may take that long because the underlying claims are still going to take time to resolve. I presume in the next month or so, we should be seeing some patient petitioner claims coming into the workers' compensation courts, which would lead to the medical provider disputes as well. So, taking good records is very important. I just wanted to make this one distinction.
And that's okay. And let me just say, Raj, it's so stark when you mention that, because here you have James talking about 30-day windows, and here you have workers' comp talking about 6 years. I mean, why that exists, that type of wide disparity? I mean, we understand why it exists, but it's crazy for the layperson to say, oh my God, in the ER context, I have 30 days, but in workers' comp, I have 6 years. I mean, it just sounds nuts. Just sounds nuts.
It's stark, yeah.
Yes. Okay, so let me thank Raj. Let me thank James. Thank you guys for your invaluable input. Thanks to all of our participants and audience members. Thank you, Krista, as usual. Phenomenal job. And always unsung, being in the background and in the studio. Everybody, hope you enjoyed it. Hope you found it informative. If you have colleagues who are in this situation, please direct them to us in some way, or direct them to somebody that may have knowledge of the ins and outs in the space of these two areas. That way they are not left shortchanged. We don't like when insurance carriers retain money that rightfully belongs to the medical community, and unfortunately it happens too often and too much. So having said that, I wish everybody a great day, and look forward to doing this again shortly. Bye, everybody.
Take care, everybody.
Bye, everyone. Stay safe.